We'll call the Collection Service Board January 9th, 2013. Call it to order. Ms. Hancock, would you read the roll, please?
Bill. Bart Howard.
Present.
Elizabeth Trinkler. Elizabeth Dixon.
Present.
Steve Harb. And Chip Hellman.
Present.
Mr. Chairman, you have a quorum.
Ma'am. Will everyone review the agenda? Any additions? Is Mr. Bond on here, Don?
No, we didn't want him.
He's just a visitor, okay.
I may request permission to address the board at some point.
Thank you for not using a dangling participle or preposition.
Minutes, did everyone review the minutes? We got them, I think they were late, probably 15 minutes after I got home.
Yeah, exactly.
Do we have any additions or corrections to the minutes?
Nope.
Okay. If not, I'll entertain a motion that we approve those minutes.
Move we approve.
Motion been made to move, seconded.
Second.
And seconded, all in favor?
Aye.
Robert's Rules of Order, every year we have to agree that we will use Robert's Rules of Order. I think we're pretty good about that. Is there any questions about Robert's Rules of Order or why we use it? If not, I'll entertain a motion that we approve the use of Robert's Rules of Order.
Move we adopt those rules.
Those rules
Chairman.
have been moved. Did we adopt? Any seconds?
Second.
And seconded, all in favor? Aye. Motion carries. Mr. Whitaker, the legal report, sir.
Thank you, Mr. Chairman. This legal report is a little bit lighter than last time. We were able to clear off quite a few cases, and so the stack of paper isn't nearly as tall. I believe there are 17 complaints on this report. I did have to write in some information about just basic year of licensure, things like that the board likes to see on number 17 because I did not copy and paste it. And so, but it's on there so you can look at it. And if you have any questions, I'm always happy to entertain them. And this time I'll turn it over to you, Mr. Chairman, so that the board can review the legal report and just read through it. And if you have any questions, mark them as you go, and then we'll take questions at the end and then have a vote if that meets your approval.
Yes, sir. Okay, we'll take just a minute to read the complaints and recommendations. walk
No.
And I do go, we're on the legal.
Here we all are.
Yeah.
Who knew?
Can't trust you right after. We all done?
Oh, go ahead.
Questions?
Yeah, I do have a question. Number 11 and number 17 are similar complaints where the complaint alleges that the respondent did not provide adequate surety bond coverage, and then both of those say the investigation revealed that it did provide that information. Is there first off, how are you made aware of that? Who raises that concern? Is that a staff concern?
Typically, surety bond complaints are opened by the staff, and sometimes what you'll have is, like, the most frequent thing is that sometimes, like, paperwork might not get here because of a mailing mess up or something, like, and the agency can actually prove that they sent it, and they can show me, like, a properly dated FedEx receipt and a bunch of documents that were in there.
Okay.
And it just, for whatever reason, it didn't make it to the mailroom or something.
Okay.
Or what have you. But when I phrase it that way, it is intentional to indicate that they were in compliance, but that for some reason or factor beyond their control, board staff just didn't have the paperwork at the time. But it's not because they didn't do it or just forgot or were trying to not do it.
Okay, so my question is, in a situation like that, do we notify them by mail first, or, I mean, we're opening up a complaint for something that ends up being a miscommunication, clerical error, mailroom.
Right.
Do we give them a chance to, or are these people who might, or companies who might have ignored our request? And I realize they've complied, but if somebody picked up the phone and said, we didn't get your surety bond, well, yeah, we sent it, kind of thing, or do we open up a complaint and have to go through this investigation? Or is it the same either way?
It really varies on a case-by-case basis. Sometimes that happens, sometimes not. And sometimes, the staff will send a letter to them saying, hey, look, if we don't get this by such and such date, we'll open a complaint. And then they do send it, but it doesn't get here by the date to open the complaint. So the complaint gets opened, and then it gets here, and then by the time it gets to me over in legal, then, all the paperwork is nailed down and ready to go. So
It certainly helps our resolution numbers look better to open a complaint.
no, that, and I'm not after that.
I know. It just seems kind of silly if they sent it, to have to go through this process. It costs everybody time and really money.
And the good news is the number of these cases is trending downward drastically.
Good.
Because of the very point that you brought up, the staff has made some changes in how they do things before complaints get to me, and I've spoken to them about that, and they're great to work with about that sort of thing. And whereas before we might have half a dozen or more of these on a given complaint report, it looks like there's maybe 2 on this one.
Right.
So it's going in the right direction, and I think those sorts of complaints and resolution are headed toward extinction, or at minimum being the exception rather than the rule. So
That's great. I also have a question about number 1.
sure.
If you don't mind. What type of business was this? Is this some company that's acting like a collection agency, but they're not licensed, or did they not normally do this, but then in some way, in this particular case, they assumed a role or implied that they were a third-party vendor?
No, in this particular case, the complainant wrote in their complaint itself that it was his impression that they were holding themselves out as a law firm, which would be exempt from licensing requirements. And so for the first phone call or so, they never came out and said, hey, we're a law firm. But the name of the agency, if you just read it with no other context, kind of looks like a law firm.
Yeah.
And you call and you're trying to do this, and somebody else who is in the business might just think you're a law firm. But then that turned out not to be the case after you Googled them. And not only are they not a law firm, but they don't have a license. And then as my description indicates, after being advised, hey, you're not a law firm and you don't have a license, but you need a license. Well, first they try to say, oh, well, this is a commercial debt, so we're exempt, blah, 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 but it really wasn't. So even after being told you're not a law firm, so you need a license to do this in Tennessee, they still made at least 2 more phone calls attempting to collect this same debt. And that's
So my question regarding this debt, that is true, is this company acting, is this how they principally make their living by collecting third-party debts?
It appears that way.
Okay.
And, you know, there are states who don't even have regulatory regimes like Tennessee does. And in those states, if there's no licensure requirement, then they certainly be free
Yeah.
to do as they please in
Okay.
those states, but not here.
Okay.
Is this company in another state?
Yes.
Okay.
Is this a debt that they purchased?
I'm not aware if it was a purchase or an assignment, but they are not the original creditor. I do know that. They are collecting for somebody else.
Okay.
Okay, I guess you gotta follow up on these guys, they'll be back.
Well,
They're not gonna fold their doors because,
Well, they may fold their doors and stop making phone calls here, and that's what we're after. So,
and that's really where I was going with this. That this is one complainant, one complaint, but how widespread is this? But we don't know that. I mean, that's not
Well,
really your job, I guess.
I do know that there hasn't been a complaint against this entity before that we can find here in Tennessee. I don't know about elsewhere. However, I think it's fair to consider if this entity is engaging in that kind of conduct with what turned out to be, unfortunately for them, a relatively sophisticated complainant who knew their rights and knew what to do and all of that. If they are acting in that manner toward somebody who is sophisticated, imagine what they might be doing to a less sophisticated
I
consumer
understand.
or complainant. I
Yep.
mean,
And how widespread this might really be was my concern. No way really.
$4,000 will get their attention, for sure.
I believe it would.
Yeah.
I have a comment about just the two cases in here about student debt.
sure.
We're going to be trending upward in that category, I would assume. And I'm
I'm-
surprised we haven't seen more to this point.
I'm well aware of that. You know, by most consensus estimates, outstanding student loan debt in the United States right now is about $1 trillion.
It's 25, like 25,000
It's
per borrower, I think.
It's not
I saw
small.
that recently.
And the conservative end of the numbers estimates between 20 and 25% of those are in default. Probably that same amount are in forbearance or otherwise not required to be paid right now, but may well head into default.
And a lot of people don't understand it's non-dischargeable debt, so.
Oh, no,
No,
they don't. But I'm in agreement, and we probably will see more of those types of cases and complaints. Let me see which complaint it is.
Does that mean that, I mean, I was under the impression that, you know, I mean, it appears to me that the government is becoming more, what's the word?
Aggressive?
Yeah, exactly. And I just didn't realize that loan collection agencies were able to, you know, purchase the debt or not purchase the loan information to be able to make the collection. So it's interesting. It's an interesting
The student
dynamic.
loan association, the student loans have always been referred to agencies for years. We used to-
Have they? Okay, all right. I thought, who I thought collected it, but I just didn't, okay. Yeah.
And the difficulty is not necessarily in the college-educated ones, it's the cosmetology and truck drivers and those kind of student loans that are real problem.
Well, interesting.
And on that same note, when you say an administrative hearing before they can have their wages garnished, is that before the wages are garnished or after the wages are garnished, then they get an administrative hearing?
No, they get a hearing before the garnishment order is ever issued.
Okay.
In number 5, which is the one I'm assuming you're referring to, this was a whole area of the law that I kind of had to learn about almost from scratch. I mean, you know, in the abstract, you would think, well, there should be some sort of process like this, but never having been through it myself or really know anybody who had, this is kind of an issue of first impression for me to learn about. And so,
Did they issue a wage garnishment before they had the administrative hearing in violation of some?
no, I did really dig into that and make sure that all the deadlines on the federal side were complied with, the notice requirements and things like that. Because the way it works is, if there's going to be a wage garnishment, then the agency in question has to issue a notice of intent to garnish wages. After that notice is issued, the debtor has a certain amount of time to request an administrative hearing, and this debtor did so. And as I understand it, the administrative hearings are similar to appellate courts in that it's mostly on written documents. I mean, both sides submit their paperwork, and then if the hearing officer has any questions or needs to hear from somebody, then arrangements will be made for live testimony if it has to be. But in this case, that wasn't done. The debtor, who was the complainant in number 5, raised pretty much all of the claims, defenses, and what have you that she raised in her complaint with us before the administrative hearing officer, and the hearing officer determined that she wasn't able to meet her burden of proof, so the wage garnishment was allowed to go forward. Now, I have some personal policy differences with some of how this whole administrative and hearing regime thing is set up on the federal side, but that's so far outside of my bailiwick and jurisdiction that I couldn't remotely do anything about it. But what I could do was really look hard into it and make sure that the agency that was before us did what they were supposed to do under federal law. In this case, it looks like they did. It's unfortunate that there's nothing really that can be done for the debtor in this case, but to the extent she had the availability of a quote day in court, she had it and wasn't able to prevail.
On number 3, there used to be kind of an industry that would advertise in the classifieds of the newspapers to buy judgments, and they would, for $300, they would give you the tools that you needed to go to the courthouse, look up judgments, and then buy them and attempt to collect it. And does this appear to be one of those things?
To be honest, Mr. Chairman, I'm not exactly sure how they got this debt. Much like any of these other kinds of debts, it was most likely assigned or bought from somewhere. But
It wasn't a judgment.
No, it wasn't a judgment. Really haven't never seen these folks, this agency before, come across my desk. Don't know just too much about them, but once if they were a multi-time offender of attempting to collect a debt without license, then we probably would go after them a little harder. But in this case, the other side of the coin is you have to look at what do you know versus what can you prove at a formal hearing. And if you've got a complainant who is happy with the way things resolved and really doesn't want to go forward, then yes, what this board does a lot of and mostly is enforcement, but there's also a public service and public protection component to it. And if through our actions and dealings with agencies or non-licensed entities, we're able to get to a place where the consumer who had the problem is now happy and it's been dealt with appropriately, and we may or may not even see these folks again, then
Text.
yeah.
On number 5, just real quickly, I assume that there is a contract, the student loan contract provides for, it says here, collect more money than was owed, that the agency was trying to collect court costs or attorney fees or collection fees.
Well, in this case, the debtor's claim was that she had made a payment of $1,800 that she had not received credit for. Based on the documents in the file, her statement was that she thought that she had documents to prove that, but that they may have been lost when her home was destroyed in Katrina back in 2005. Because the underlying student loan debt itself was dispersed in like 1993 or 1994. I mean, it's a long time ago. And so her position was, look, I refinanced my house, got some money out. As part of that money, I made this payment, kept the document, but, when the house went away in Katrina, the document may not have survived. And I'm assuming that at that hearing, she couldn't produce any such documents, otherwise she probably at least got the hearing officer to give her credit for that payment so that the balance that was subject to garnishment from her pay would be lower.
She got what she wanted. On number 12, the agency apparently contacted the respondent for the claimant about his son's death.
Right.
Do you
Well,
think we should-
That's not entirely accurate. That the initial dunning letter was sent to the last known address of the son, and the father opened the son's mail, and that's how he got the information to be able to call these folks. Because the son had in fact lived there at one point previously, but I guess once this estrangement thing happened, moved away and they don't speak anymore.
Any other questions?
I have no other questions, Mr. Chairman.
Entertain a motion that we approve the legal report as written. And
I
moved
second.
And seconded, all in favor?
Aye.
Thank you, Mr. Whitaker. Administrative report, Ms. Hancock.
Did you want to update me on this?
Oh, one quick update, Mr. Chairman. This nice lady that's leaving right now, this litigation attorney that's been assigned to the board, her name is Robin Ryan. We are scheduled to have a formal hearing before an administrative law judge sitting alone on January the 22nd, previously continued from December the 4th, I believe. And so we just wanted the board to be aware of that. Mostly if the respondent doesn't like the result, there's a potential for an appeal, and the first level of appeal would be to the board. So there's a possibility that might come down the pike in the future. It's not today or tomorrow, but we'd like the board to be aware of that. And so if you have any questions on Ms. Ryan, I'm sure she's happy to answer them. Otherwise, she's going to go do other stuff, I think.
Is the board supposed to be here, or any member of the board?
You know, the administrative law judge, you are welcome to be there in the audience, although that could prejudice you.
Yeah, I don't want to know that.
And in fact, I would advise them not to be here for an ALJ only.
Probably a good
Hearing.
idea. And the process is this: if they won't, they should and appeal to you generally. You would then have, you would be done on a review basis. And the first thing you can do is decide whether to adopt what the ALJ did or not adopt what the ALJ did. If you don't adopt it, we have another hearing, we'll have to approve. Otherwise, it wouldn't be here for you. And if we or they are upset with the results of any of that, the next step would be appealed to the Chancery Court of Davis County. And then you would be sent to the AG's office, who then handles it on the state's behalf, whatever we decide. But you'd be getting, if it's a decision that we think is terribly wrong, we bring it to you first to see if you agreed or not agreed.
Is the testimony of public record?
Oh, yeah, well, there'll be yes. there
Will it be on the collection? Will it be on our website?
No, the testimony won't be on the website, but there will be a court reporter there, and it would be available at that point. And in the event that it is appealed to you, I would advise not looking into that. But, I mean, you can't help it. This is
Okay.
Okay. Thank you.
Robin. Nice to meet you. Conflict of hearing, or conflict of interest?
Yes. First thing under my administrative report, you'll find in your blue booklets in front of you, there's a form, conflict of interest form that we ask all board members to sign at the first meeting of each year. So if you will fill those out and send them back around to us, we would appreciate it. And I'll send the minutes approval around for your signature, Mr. Chairman.
Complaint comparison report.
Okay, Under tab 2 is the monthly complaint report that I provide to you. The top grid is from information from January 5th of 2012. The bottom grid is January 9th, today. You'll see as of January the 5th of 2012, you had 90 pending complaints, 37 of which were over the benchmark we tried to achieve 37, 59%. In the today's information, we have 41 pending complaints, down considerably. As I look at Terrence, with 13 over the 180 days for 31.71%. So,
Excellent.
big improvement.
Yep, that's great.
Congratulations.
And I would be remiss if I didn't mention that Mr. Bond got me off to an excellent running start to help fix those numbers.
Budget report.
Budget report under tab 3, the first, and our colored printer is down. I apologize for that. We had to give you black and white reports this month, but the first, you'll see there are, the first 3 years are just comparison reports. Those are closeout figures for revenue that we've received and where that revenue comes from. For example, location managers, application and license fees. You'll see 24,400 was received for the entire fiscal year of 9 and 10, 25,775 for 10 and 11, 15,175 for fiscal year 11 and 12. The right-hand column is to date through 11/30. We've received so far 13,550 for that category. And renewals right on down the line, you'll see the totals then received for location manager fees. And then the bottom block is for collection agency fees for those 3 fiscal years, and then where we are today through 11/30 in revenue.
Is the reduction, do you attribute that to the lack of being able to give an exam?
You mean last year, 11/12 reduction?
Well, actually, it's down this year too.
Well, we're only halfway through the year, fiscal year.
Oh, I'm sorry. Gee, nothing yet. Okay.
Yeah. So, we're almost,
Right.
yeah, well, just for through 11/30 in location manager fees, we're almost received as much as we did the whole year, last year. And this is our big renewal year, so that revenue amount will come up. And you'll see at the bottom how it kind of goes. 9 and 10, our total revenue received was 210,772. Then our big renewal year, 10 and 11, was 396,740. Back down again in 11 and 12. So we're expecting, with this being a renewal year, we'll be around 350, something like that. Hopefully 390. Up more.
You can't just spend and split the money up.
I don't think they let us do that. No. The next page over is your is the expenditure report. It's basically the same format. You'll see the 3 fiscal years we give you in a comparison, and then that last column is our expenditure report through the end of November of 2012. We always run about a month behind getting these report figures. So you'll see the salaries, the benefits, the employee benefits, travel, all the way down so far this year, or through 11/30. The revenue, the expenditures rather, was 86,013 so far. And then that bottom block is where we are with revenue. Just to kind of give you a comparison, revenue versus expenditures. So, if there's no questions on the budget information.
Anybody have any questions?
No, sir.
If not, I'll entertain a motion that we approve that
So moved.
and moved. Is there a second?
I'll second.
And seconded, all in favor?
Aye.
Next on the agenda is if you'll recall at our last meeting, I provided you with some tips and just basic information about debt collections, things that consumers might want to know in Tennessee that I would like to post to our website. And you took the reports home with you and looked over them. I got some suggestions back from Chairman Howard, and this is his suggestions here. You'll see what's highlighted. He had marked through that first one there, and instead of collection, he put a collector. Again, our color printer, I would have had these highlighted, but it's broke. And then he struck through some other areas. I'm totally fine with what suggestions he's made, and if any of you have any other changes to it or objections to it, to putting it up, I'd like to know.
I like the changes.
I do too, I think.
Thank you very much.
And it's what we had discussed
Yeah.
pretty much last time, so.
Okay. So with your permission, and then again with legal review of it, maybe
Someday it'll be approved.
maybe Mr. Whitaker would like to add a disclaimer or something to it, that this is just information and tips, and we'll get that on the website.
May I be heard briefly on
Yes.
this issue? I just happened to learn that this was going to be presented a couple of days ago, so I hadn't had a chance to speak with any representatives from the Tennessee Collectors Association and see what their position might be on these tips and whether there was any industry input that might inform the discussion, or at least give you some sense of how the industry feels about some of the wording or some of the tips, whether it's advisable to put on there, because certainly I'm not speaking on behalf of TCA, just a member of the industry, but my personal concern, and I'm sure the industry shares this concern, is that consumers are advised properly as to their rights. The FDCPA is a very tricky piece of legislation that even seasoned litigators have trouble understanding, and it's always important to reduce these complicated provisions into easy to understand plain English. However, you don't want to, doing that, you don't want to sacrifice any of the clarity of those provisions and misinform a consumer as to their potential rights or as to a debt collector's obligations. So if you all are of the mind to approve this for posting today, I would ask that you delay final posting until I've had a chance to obtain a copy and perhaps distribute it to TCA members, and we can perhaps convene for a discussion on the provisions or what's going to be posted, perhaps provide some feedback to you all for consideration.
I think that's fine. I would entertain a motion to table this until our next meeting, give the industry an opportunity to review it, look at it, make any suggestions. Chris, I suppose you had an opportunity to look at it. Did anything just glare out at you?
Nothing right off the top of my head. Some of the more potentially problematic language that had been put out on the first iteration of this document, having been marked through, changed, and what have you. I think it's definitely an improvement. But as I was discussing before, I think this board, there are multiple stakeholders, and the mission or missions of this board, part being the public and part being the agencies who are subject to regulation by this board. And if there's potential feedback and the possibility of an improvement, I don't see a problem with that at all. I would be clear, though, to mark anything that is distributed as for draft is something along the lines of draft purposes only, not in final.
Consult your own lawyer.
Right, whatever's released would be for discussion purposes amongst us, and let me also be clear. Our intent is not to delay the posting of information that will be helpful to consumers, but we do want an opportunity to participate in the discussion. Unfortunately, this was the best way that we can do it, by appearing at, or this is the best way that I felt it could be done, by appearing at a meeting where it's going to be discussed for the first time, and present concerns that I think would be shared by the industry or industry representatives, whether industry representatives.
I think that's absolutely right. And our purpose is more than anything else is to give the consumer some real life information, because they're being bombarded with pay $600 to get your credit cleared up, and we want to give them that opportunity. And more people are looking at that website to get information. And on the other side of it, reserve some telephone calls to the administrative office and what have you. So I think the concept is good, but I agree that it needs tweaking and input from the industry.
I'm making a motion.
The motion's been made to table this until our next meeting, and the industry have an opportunity to see it.
That'd be, and it'd be clear that it is a draft or working copy only.
Yes.
And is there any other, is there a second?
Second.
And second, is there any other discussion?
No, you first.
I just have a question, Mr. Bond. Do you represent the association, or are you on the board?
I'm not here on behalf of the association, however, I will be taking this to them for discussion purposes. Just assume after obtaining copies as possible.
That was my question, is how they're going to
We
get it.
don't want to, well, we certainly don't intend for this to, we don't intend for this discussion to be ongoing past the next board meeting or even have a round.
That was going to be my point. I don't want to just table it indefinitely. I think we got to give TCA
The idea,
time limit.
Yeah, the idea on our end would be to move on as quickly as possible. If that means I just have to go it alone and present my own concerns, as an industry-involved attorney, then that's fine. But I would like an opportunity to just give them a chance to weigh in and see if they're concerned on that side. And I certainly do not want to delay, as I said, the posting of information that will be helpful. So, I'm sure the industry certainly supports that.
All right, well, the motion was to table until the next board meeting, so we'll be up for vote then. Motion's been made, seconded, and we've had discussion. If all in favor, say aye. Aye. Motion carries.
Tab 5 is an issue regarding 2 offices, close proximity, location managers serve as such for both. And let me just read the paragraph into the record, the question. Have a client who has 2 offices in the same office park 1,000 yards from each other. Each of the 2 offices have collection floors, but only one office. I think he means administrative office. The principal office has all the accounting records and handles all walk-ins. The second office is just a collection floor, and all payments are directed to the main office, and all collection letters have the main office address. Having said this, is a separate license required for the branch office. It's not like the other offices across town in another city or state. So,
I'm having trouble understanding this. Is it a branch office?
It's a
Or,
collection floor.
or is it a
Call center. The call center is in one part of the
Office park.
office park, and the administrative offices are in the other
right? Well, that's different than, in my mind, than a branch office.
well, the second letter over I received from him Monday, and it's a little bit different. And he says they are located approximately 1,000 feet from one another. The reason they had to be in 2 different buildings is because the main building could not accommodate the additional office space needed for the collection floor. That's about all the different information it is. But
I
think that was their question. Does this meet the definition of a branch?
The collection letters that just have one, there's just one address that goes out on all the addresses.
it's like this building and that building, us having, if we operated a collection agency and we're just kind of a little offset building or branch or part of the main office over there, would we have to license this location?
I think the key point on which this inquiry turns is there substantive collection activity going on in both places? If there is, then maybe a separate license is required, but if you've got one location where all the collection activity happens, and that's where people go to make payments, and that's
where the letters
the address is where the letters have on them, and then you've got the quote administrative part. Let's say they just handle payroll and HR and stuff that makes the business go, but doesn't do collection activity.
They have 24 collectors, 17 collectors are in the main office, 7 are in the other office. So the way I look at it, they need a license for both locations.
I think if they have collections going on in both.
Yeah, I mean, it's.
If they didn't, if it was what Chris said, then I would say no, but
And-
they just
and-
need to move those 7 people.
Yeah.
Well, that's what I was going to say. I mean, it's a difficult question because if, Donna's point about these 2 towers is a good one. How different is it really if, their collections are on the 2nd and 8th floor of this building
Now, that's
versus
what I was gonna say.
the second
That
floor.
happens all the time when, it happened to us, but I've seen other companies as well that operate in an office building and they get blocked in by space and they gotta hop the floor and continue to expand their business. There's no way around that. Or looking at it another way, collection manager manages a large operation. You go to some of these large companies, there's no way. I mean, I would argue that one building over may be better supervised than on the same floor in a very large. It's really hard to distinguish. I mean,
Once again, it's a slippery slope.
yeah, it
We
is.
start on that, and
Say, okay,
Good
well,
for
1,000
them.
yards is okay, but not a block.
exactly.
Right,
You know what I'm saying? I'm not unmindful of the potential business impact it would have. I'm just not sure how much.
What about a company that has 2 floors of a building with one manager?
Well, I think actually the board's already discussed and made a ruling on that in another presentation at a board meeting and said that would be acceptable.
Okay.
Because it is within the same building and, location manager, the intent is to have somebody there on site full-time responsible for stuff. And, if all they have to do is hop on an elevator and go from the 2nd floor to the 5th floor,
Okay.
then that's, I think that's.
And back to what you had said originally, there was something that came to this board a year or so ago, that maybe even 3 years ago, that the collectors were in another state, but administratively administration was in one state, collectors were in another state, and we ruled that both of them had to have a collection manager's license. So if it's 1,000 yards or across the country, I don't think the board has the authority to decide how far apart you have to be in order to have 2 licenses.
I agree with the statement about a slippery slope, because what about a building that has a hallway down the middle and you have collectors on one side of the hall? You see what I'm saying? I'm not going to argue. I don't feel that passionately about it, but
So bottom line, if I'm understanding the board correctly, same building location, mailing address, if there's different floors or something, that's fine, if everybody's going to the same place. But if it's separate buildings, then that's kind of the demarcation line if you've got substantive collection activity going on in both places.
Yes.
And I think even if the administrative offices are in one building and the collectors are in another building, you have to have 2 licenses. We ruled that way before.
I don't know if I did.
That may be a separate issue for another day,
Yeah.
for another
I'm
potential.
not bringing any. I'm just telling what we've done, what we had decided before. And if the in this case, if the administrative offices is 1,000 yards, what's the difference between 1,000 yards
That's
and
cool.
1,000 miles?
Aren't there collections going on in both places?
Well, in this case, that's what it
They
sounds
are.
like to me.
That's where my problem is. with it.
Yeah,
It's collection
Yeah.
activity. That's
Right.
what my recollection is, that we hinged it on, is collection activity.
So, are you saying, because I wasn't here when you all made that those rulings, or those opinions, but are you saying that if, in this case, if they didn't have those 7 collectors in the one spot, it was just administrative offices?
I think that would be okay.
Okay.
But
I mean,
I
I
don't-
do too.
I don't honestly recall.
but- Okay.
Yeah, you're requiring that other location to have a bond, to have
There's a branch
another
manager.
location.
There's a branch do they have to have?
Branches outside the state of Tennessee are standalone licenses, just like anyone else. We only issue a branch if it's a separate location in Tennessee. And so they would have to have a whole new license, bond,
Well,
location
these are
manager,
just 1,000 yards apart. Are we talking about 1,000 miles or 1,000 yards?
1,000 yards.
Right. I don't think that they would, I think that they would certainly meet the requirements of the branch.
So then
Are
we
both
have to have a
places in-
separate location.
But they have to have separate location managers. 2 location managers, but 1 license and a branch license.
No, what, okay. Months, maybe 2 years ago.
Please.
Because this is,
I'll be able to offer some historical insight
yes.
since I was around whenever we first had the discussion. Okay, so what, I believe this is 162105, I don't have the statute in front of me, so I'm just remembering, but I believe the statute says, a collection service maintaining more than one place of business in the state shall register each other location or something similar to that effect, such that if you have, and I don't think that they intended to get so specific as if they're 1,000 yards apart. I think if you had independent business operations, which are all under the same legal entity name, and they're the same collection service, and they each do business in the state, and they each do collection service business, so it actually has to be defined as collection service business in the state. You have to register those locations, and you may even have to indicate the nature of the business done at that location. I'm not sure if the statute is that specific, but I think that that intends to capture separate businesses that are in different locations. I think they're thinking of different cities or in different cities, or maybe at farther apart locations in the same city. And the requirement of those is not to obtain a separate license, it's just to register. So they just have to be of record in the board office that those agencies exist. They exist by virtue of the name license that is granted to the first location of the collection service in the state. So any other location that springs from that would be considered a branch in the state, and they would be required to be registered as a branch location of that original licensee. So if there's action against the original licensee, it similarly affects the rights of all those branches. Whatever action is taken against them would have a similar impact on the branches of that original licensee. I think the board decided previously that they would be required to have a location manager by virtue of the language in our link that says each collection service shall have for each location in which it conducts business. So that would capture branches as well.
So they do need a location manager.
You need a location manager, but not a separate license, was how the board had ruled previously. Now, if you were outside of the state, not stated correctly, you don't fit the definition of a branch in accordance with 105. You are considered just a collection service that needs a license.
But I don't recall there was any discussion of what they were doing in that branch. We just sort of assumed if you have a branch, you're doing collections. That's the reason you open up a branch. So I don't remember this saying, but this is just our administrative offices. We don't do any collection. I would think we probably would have said, because the whole point of the location manager is sort of to supervise collections, it seems sort of ridiculous to have a location manager supervise
Non-collection.
non-collection
I think you're
activity.
right. I think you're
A conference room and administrative offices,
Right.
you know.
I don't think
So-
I drew that distinction carefully enough.
I don't
Should
remember us
have.
ever having that discussion,
Because
but
I
I
agree
can't.
with you that if you're not performing activity that would meet the definition of collection service business under 102.3, then there's no point.
I think the
in actually
spirit of the law
requiring-
is-
Exactly.
Yeah.
I don't think the legislature intended to regulate those aspects of business.
It's just easy to understand.
And that, I guess that's where I was.
So that's what I'm
coming
saying
from,
too, yeah, I
because-
feel like if they move those 7, in this case, if they move the 7 back, you know, so
Yes.
that all collection activity is being done in that one place.
Right.
Then
They
I,
move the administration office to the other place to get rid of these 7 collectors.
Right.
Come back in, and they're all
Why
right.
don't we all fly to Colorado and
thinking-
see for ourselves?
but I think going forward, I mean, we may have this again and
It makes companies move.
Well, I think the spirit of it, when I think of even, and I know we've said if they're in the same building, that's fine, but the spirit of it is the location manager is able to oversee all collection activities, even in the case of somebody in a high-rise office building. If they have collectors on floor 15 and collectors on floor 2, it's going to be very difficult. I don't care if you jump in an elevator, climb a flight of stairs, or walking across a breezeway. It's hard to supervise all those collectors. So I guess that was my point with this, that if they have administrative offices in one area, if there aren't collection activities happening there, I feel like that collection agency manager can oversee. They move those 7. So that feels better to me.
Are you confused?
Yes.
Did I just
To say the
confuse you?
least. I mean, you surely don't expect me to write a letter and say, move your employees.
No, I think the answer to his question is yes, you do have to have 2 licenses.
In it,
If you have collection activity going on in both places.
that's
Then
the
they can make the
answer.
decision, they can figure out what they need to
So
say.
we're going to require them to have,
Or they have to have 2 locations.
2 location.
2 location managers.
that's,
Well,
Now,
but do
wait,
they have
now,
to-
if it's an out-of-state collection.
No. Oh, it
it
is?
is out of
The
state.
board previously treated out-of-state collection agencies different. There was no branch issue with out-of-state. You were simply separate locations of collection service business. However, I think the analysis still applies that what you're doing at that second location would not meet the definition of collection service under 6221.23. Then there's not a licensing question. Well, there wouldn't be.
Especially if they're not collecting in the state of Tennessee.
Right.
And they have 2 offices and they are collecting, will they have collection
They have
people
collection employees in both
in
places.
both places?
Well, that's up to the board to determine whether they think that meets the definition.
And that's why I brought it to the board, yes.
Hey, I was just here to provide insight on what the previous ruling is. I'm gonna go back to
So
the
do both locations need
Like
licenses?
separate
or
licenses.
Just location?
And we decided that if the corporation is located in another state, they cannot have branches within that state.
We had, but the way I understood
This
it
is
was
the
that-
way, let me read 105 that Terrence just referred to. A licensed collection service maintaining more than one place of business within the state, and we always determined that was within the state of Tennessee, shall register each place of business with reference to its specific location, name, and purpose upon application for license and upon subsequent renewals. That means if you have more than one location within the state of Tennessee, we would ask for a branch office application and license and a separate location manager. If
Question,
it's outside the state of Tennessee, they had to have separate licenses total.
Bonds and everything.
Bonds, location manager, everything, unless they were incorporated.
Well, that's if that location was collecting from Tennessee consumers. Like, if it's just a company, at least that's what I remember now. If it was a company that had branch locations, but in these other branches, they didn't have any Tennessee clients, they weren't calling into Tennessee, then we didn't care, obviously. It didn't matter. But if they were doing collection activity in the state of Tennessee out of that other location, then they needed the license. That's what I remember us saying. So that would be the question to them too, if those, you know, are those 7 people in that other building, are they serving Tennessee clients, calling Tennessee consumers? If they're not,
Well, I assume they are, that's why he sent me the letter
Yeah.
asking the question. So, again, it's back to 1,000 yards apart, 7 people over here, a group of people here, all doing the same thing. Do they need separate licenses?
Donna, can you read me that portion of the statute again?
105.
Within, does it say within this state or
Yes.
within
Those
these
In
states?
this state.
It does say this state? Okay, well, this,
No, it
that
says-
means Tennessee.
It says
If it was
place of
said,
business within the state.
my point was going to be, if it had said within the state, then there's at least a colorful argument to be made that, as long as its other branch was in Colorado too, then, maybe there's some consideration there, but within this state clearly refers to Tennessee, so.
Does not say this state, it says the state.
No, it says this state. 6220-105C.
Collection service maintained more than one.
Oh, I'm sorry,
licensed
A.
business.
A is what I was looking at, sorry. But C is the one I read, and it does say one place of business within the state.
I honestly thought though, if it was, the board had decided about a year ago that it was a corporation, that was a single business, and if they have multiple locations, they still didn't have to have each location, but they had to have a location manager of each one, because the question
If they were
came up.
collecting the state of Tennessee, that's what I read.
I thought it was outside Tennessee.
Okay, this is what I remember. A corporation is treated as a single legal entity. So the discussion was licensed according to a number of legal entities that exist. A corporation is a corporation, a single legal entity. One license is sufficient to cover all the businesses that are all the businesses that exist under that single legal entity. So it actually makes that single entity would affect the licenses of all the different iterations that they have of that.
So they didn't have to have a branch license for each location, but they had to have a location manager for each one.
They have to have location managers for each, yes, and a single license for the corporation that exists for the corporation.
Because we had discussed how hard it was going to be to keep up with that.
You just can't deal with them branch licenses. You just can't deal with them branch licenses.
Can we just send a letter that requires a location manager if they're doing loan collections in both locations, and see what his response? I mean, I think we can't cover all eventualities, even though we want to, because there's some interpretation involved in this. So I say we send a letter saying, if there's
Basically-
collection activity going on,
from consumers in the state of Tennessee.
yes, then you need location
Then
managers
you need
in
a
both
location
places.
manager for your second site. If there's not collection activity going on, or if they are not collecting from consumers or clients in the state of Tennessee, they need.
For that matter, that would be another way, instead of moving the collectors back, they could actually
Move the
move
business.
the business.
Those of us that are in the collection business understand that very likely you're going to have a debtor that has an account in Kentucky, and he also has an account
Yeah, I
in
know.
Tennessee, and you're going to be collecting them from both places. If I were trying to run that business, I would be confused. I'd be nervous about what I was doing.
Well,
You got to think about sales,
I'm
too.
gonna sort of raise another question. This is really opening a can of worms, probably. But this business, I won't mention the name, but it seems to be a licensing LLC or.
They're a service that licenses.
Okay. So whatever answer we get, we're not convinced necessarily by this. We know where this person's located, but he may be inquiring for somebody who's.
Florida.
Yes.
True. Good
Right.
point.
So whatever answer we give him, it needs to probably cross boundary. In other words, I think your response was a good one and would cover any state, but we don't know what state he's inquiring
It
for.
really doesn't matter.
And with that response, it
And this is
doesn't.
Tennessee, and then it would make a difference.
Well, what we discussed earlier was if you're out of state, each location needed to be licensed. But if you're in the state, you have one license but multiple collection licensed managers. And he hasn't defined what state
He
the
doesn't say what
operation.
state he's in, but this collection licensing LLC is a company that goes through the
Right.
processes of licensing. You know,
So he could be representing a Pennsylvania company,
Right.
as an example.
or a Tennessee company.
Right.
Okay, so if it's a Tennessee company, I'm to require a branch license and a location manager. If it's an out-of-state company, I'm to require what?
A location manager at each location where collection activities going on.
Well, let me even make it a little more difficult, and maybe simplify it. You have salespeople that are out selling Bank of America Well, they're selling Bank of America for accounts in Tennessee and in Arkansas. So I think the fact that if they're doing sales to somebody that has a company in Tennessee, then they're going to have a license, whether they have debtors in the state or not. If they're selling to a company that would have debtors in Tennessee, I think they're required to have a license.
Branch license or standalone?
I think a branch license, because it says the state. It doesn't say this state. A says this state, but C says the state.
Well, then if you go by the state, then we're going to have to change what we've been doing in the office and the requirements we've been asking for the past 2 or 3 years. Which is, we only license branch offices if they are physically located inside the state of Tennessee. Outside the state of Tennessee, if you're doing collection business in Tennessee, you hold your own license and the whole license requirements. If we're going to change that, we need to,
I think to add to what Don's saying there, I think that the way that's going to have to come about is because those aren't just procedural, those aren't just procedural requisites. They are in fact interpretation of the law that govern the person's entitlement to a license or potential disciplinary action. So I think those are going to have to be presented in concrete form. I know that's something that we tried to bring to fruition while I was here, and kept running into various roadblocks and never could get those rules off the ground. But I think the board's going to sit down and find an announcement on how under what circumstances these licenses for out-of-state agents should, I think that does have to occur.
Well, then we go through the rule. This fellow needs an answer.
Is the answer that he needs a location manager in any location where collection activity is occurring?
Well, that's the one thing we're sure of.
I think you can answer that question at this point without even necessarily reaching the question of whether they've got to have, a
Yeah.
branch license or a separate collection license, because it doesn't really sound like that's exactly what they're asking. So, to follow the legal parlance of answer the question asked, sometimes you can limit what pronouncements you feel like you should make or are forced to make if you answer the question asked. So.
Yeah, I think that's a good answer. We don't have to bring up the whole can of worms. We'll just answer his question, and the answer to that, if the board approves, what I'm about to say is that yes, indeed, you do have to have a licensed manager or a collection manager. That's what we call it.
Location manager.
Location manager in each location.
Where collection
Collection
activity
activity.
Where collection activity.
is being conducted.
I don't know that I'd even say that.
well,
Because if you've got sales in one office and all they do is sell, they've got to have a license too. They got to have a branch manager in a sales office.
well, this person will be watching this video of this meeting and the discussion. I would like to have a TCA I can quote to him saying this is what you're required to do. And I can always quote one that says if collection activity is being conducted,
You gotta have a location.
you gotta have a
That's a
license
straightforward
out.
citation.
It's like a 108.
108. All right. I will refer him to 6220-108 and expect them to abide by that.
You need a motion.
Yes, I would
I'll
like
make
a
that
motion.
I'll second it.
Motion's been made, seconded. Is there any other discussion? All in favor of the motion, say aye.
Aye.
All opposed? Aye. Motion
Next
carries.
issue I would like to bring is, you've got a letter there under tab 6. It's from a collection agency notifying us of a civil penalty that they paid to the state of Arizona for failure to submit audit reports and escrow statements. This is, the company has been renewed, but they sent this to us as part of their renewal just to notify us of that action. So Chris and I talked about this and decided we'd bring it to your attention to see if there was any action you wanted to take because of a licensee in Tennessee being disciplined in another state.
Without reading the whole thing, what was the discipline about?
The examination revealed, they had an auditor come in and examine their records, and it revealed that the company had submitted its 2010 annual audit after the established due date and had failed to submit its 2011 annual audit report and 2011 semi-annual financial and escrow report statements.
I remember when I was licensing in Arizona, they were the hardest people in the world.
Yeah, I think it's fine. They resolved it,
Very fine.
paid a fine.
And they notified us.
Yeah.
Yes.
That was good.
There's a motion made that we don't have a problem with that. That's what we do.
Okay.
Okay, look, is there a motion?
I would say a motion that a complaint not be opened as a result of this self-reported violation of another state's law.
Is that your motion?
That's my motion.
Is there a second to that motion?
I'll second that
A
motion.
second, all in favor?
Aye.
Tab 7 is an issue regarding a trust account. If you would look at, under tab 7, page 3, that's marked at the bottom, you'll see their balance sheet. I hope you're all there. Are you on that page?
I don't see tab 7.
See tab 7.
It's on there. Oh, I've got 17.
I was wondering how you found
So where's tab 7?
Should be there.
Nope.
That thing just puts them in weird orders.
Yeah.
Does it not read?
Here's the 7.
Is it tab 20?
Maybe it's under a different name. Which one is it?
It's, well, on your agenda, it says trust account.
I don't see
Well,
it.
let me send around this balance sheet showing. Here is also some paperwork, a letter from this company. The last page 8, I think, is what I need you to look at. There's an email I sent yesterday. The issue is they didn't have enough money in their trust account showing it was sufficient to pay all the clients. So we've gone back and forth with this company and asking them to get this straightened out. So it's a foreign company. They sent me this letter that's attached. It's the report basically showing that they have a lot of other interest, business interest. Collection is just one of the services they provide, and it's not the biggest part of their company. It shows they do customer service, human resources, sales, procurements, manufacturing, media and entertainment, banking, insurance, healthcare. They're a multi-million-dollar company.
Jack of all trades.
Yes, and on page 8 of that report that they sent me, she says, we never actually handle any client funds, so there would never be any amounts due any of our collections customers. Any funds collected are only paid by debtors directly to our customers, never to us on their behalf.
Their
So,
balance sheet's wrong, right?
well,
What does this number
I-
represent then?
yes, I don't, let's see. One of the balance sheet items on Form 1 prepared for them is called Accounts Payable Clients, and the balance in that amount, as of March 31st, was $299,037 USDA. We questioned this amount, because of the amount held, you questioned this amount because the amount held in trust was only $15,000. We initially provided a response that none of the funds due related to any collection customers. You indicated a more thorough explanation is needed. I don't want to read that whole letter. Listing below a summary of services that gives details about the variety of processing services that they offer across many industries from their various processing centers around the world. I don't know if she specifically stated what that amount refers to.
Well, I don't want to be narrow, but we're pretty narrow here. We don't care what they do in their other businesses. But our statute says they have to have enough money in their trust account at all times to pay their clients, and they don't. They have $125 million in their operating account. Just move some money over there.
That's my thought.
Well,
She's saying
they don't handle money at all for clients of the collection.
Well, the balance sheet says they,
Well, but that may not refer to just their collection business. They may pay clients out of that account in healthcare or in manufacturing or any of these other businesses. Yeah, that's what she said is we never handle any client funds in our collection business.
I think I'd want to go back to the statute, though, Don, and it says that you must, one, fill out a balance sheet, and two, have enough money in your trust account to pay clients that you're due any money. I don't know how else to describe it that they don't. They don't meet the statute requirement.
Well, if they had zero in both areas there, wouldn't you accept that? So, if in their collection branch of what they do, they collect zero funds and they distribute zero funds. So I will ask them to change that balance sheet and only make it reflect what they do in collections.
What they owe if they have
That's what it
$15,000 in their
should be.
trust account, then they'll have zero down here if they don't owe any collection.
Well, I guess they would have to have a separate audit of separate financial statements each year just for their collection portion of their business.
they should have that anyway.
Yeah, they
If they're
should.
as big of a company. They got
Just ask them to fill out their financials only as it relates to the collection
Collection.
portion of their business. You would think that's what they would do anyway.
Right.
Okay.
Derivatives and all, I mean, that's
Yeah.
scary.
All right. If you'll pass that all back down here,
Yes,
we'll
ma'am.
get that taken care of.
Did we answer your question okay, Don?
Yes, you did.
Okay.
May not be the question answer they want, but
I don't know how
suits
to-
me. All right, the last item I have under my report is issues surrounding certified public accountant or not a certified public accountant. Do you have to have 8 in your books?
Yes.
Okay.
Yes.
All right, that first page, Susan copied there, telling you what's in there, under that tab. There is a letter from Mr. Whitaker to this gentleman explaining that we're going to bring this to you to let you determine the issue. You'll look at the, did you put tab 8 in there?
It's in the handout.
There's a handout Susan gave you because the back page or the back,
At the top of it, it says add the tab.
these balance sheets are front and back information, and the back of the balance sheet was omitted from your tablets. So she sent around the back copy showing on the balance sheet where we asked for the name of the CPA or PA who prepared their financial statement. They showed that this gentleman was licensed in Vancouver, Canada, British Columbia. Well, we required that a U.S. CPA or PA prepare the balance sheets. So His argument is that in Canada, the CGA designation is similar to the CPA designation in the USA. And he would like for you to accept his Canada designation as a CGA in lieu of the CPA.
What was your response, Chris?
Well, as luck would have it, the other program that I'm responsible for is the accountancy board. So I went and spoke to the executive director of that program, and generally his statement is the CGA being similar to the CPA is correct, but it's not equivalent. As I understand it, if you have the CGA designation in Canada, you could register through something called IQEX, which I think is the testing body. You could take your CGA to IQEX and say, I'd like to sit for an American CPA exam to be licensed in Washington, whatever state's closest to Vancouver, whatever you want to do. And then you could sit for that exam if you wanted to obtain the CPA designation. But there are differences in the education and or ongoing education requirements of those two designations, such that the accountancy board's executive director did not feel comfortable stating that they are equivalent. And since, I mean, plain language of the statute says what it says. It says a public accountant or a certified public accountant. Chartered government accountant in Canada doesn't really need that, in my opinion. However, what I would say is if the board rules, as I would recommend that they rule, which is to tell this gentleman that they've got to have a U.S. CPA or PA do this, the board might want to vote to do a rule at some point down the road clarifying that it has to be a U.S. CPA or PA to do that, if that is the board's intent.
Is that the rule currently?
Well,
Why do we have to restate it?
well, because the language of the statute says a public accountant or a certified public accountant, but
A license.
licensed. But it, you know, although the presumption is a U.S. PA or CPA, as this gentleman is making the argument there, well, what if it really is the equivalent? I mean, maybe the CGA designation isn't, but what if the United States enters into some sort of treaty or international exchange agreement with a foreign country that says, hey, look, these are equivalent, and for our purposes, they're to be treated the same. Now,
What's the requirements for a PA? And are they federal requirements or individual state?
well, public accountant, as I understand it, is the general designation. It's kind of the forerunner to what is now referred to as a CPA. In the licensing database for the accountancy board, there are only about 24 PAs left, and all of the PAs were grandfathered in when the new Tennessee Accountancy Act authorizing statute for that program was passed in 1998. Everybody who was a PA gets grandfathered in, but you know, those folks can either stay a PA or take on the CPA title based on what they've already gotten education-wise, but no new PA designations or licenses are being issued or have been issued since 1998, and they won't be. I hope that.
That's in Tennessee.
Yes.
But they could have a PA designation in Ohio that they could use.
True.
They could use it.
Absolutely. But that would be the definition of a PA license, because they would have it now. I just brought that up about the potential for a rule for the board's consideration. If you feel the statutory language as it exists is sufficient, I'm prepared to defend that decision as well. But you know,
Well, I don't think we can change the rule today. This fellow needs an answer.
well, the answer today, based on the law as it reads, is his agency is going to have to get a United States licensed PA or CPA to do it.
I think that's it.
Which is not that difficult.
No, it really isn't. Hey, you know, it's a matter of getting a reference, calling up somebody that you know or trust, or somebody that you know knows and trusts. Send them your info, get them to put it in the proper format, pay them some cash, and get the certifications. Because a balance sheet is not nearly as in-depth in terms of analysis and document review as an audit or even financial statement is.
Exactly, we're not asking.
Because the person who is doing the balance sheet accepts all representations made by their client as true for purposes of the balance sheet. So the audit and verification procedures and things like that might run up a much higher bill for the CPA or the firm that's doing the work don't go along with the balance sheet.
I move that, go ahead, Don.
We have held up the renewal of this agency, waiting on the outcome of this decision, so do we renew them and give them a chance to correct this, or do we hold up the renewal?
I say we have to hold up the renewal.
That's my opinion as well.
One more slippery slope if we don't.
Okay.
Motion, Chris? Chip, I'm sorry. It's just that motion.
All right, did you have something else you wanted to say?
No, I was just
No, I
going to
said
say I
Chris.
can't move as a non-board member.
Okay. Okay. I move that we instruct them to get a licensed CPA or PA here in the United States to submit proper balance sheet.
Motion's been made. Is there a second?
Second.
Second, is any discussion? All in favor?
Aye.
One question, Donna, how is the administration of the test going now? Are we testing people?
Yes, we are, and as you know, instead of having to come to Tennessee, this particular vendor that we have has locations all around the United States, so it's making it so much easier for the applicants to take the exam in their home state or even their city. It's going well. It didn't start off as fast as we thought it would with the backlog of applicants that we had and all of the fussing and confusion we had because we didn't have an exam and they just sort of trickling in and taking it. But as you know, that contract will expire in September, at the end of September, so there will have to be an RFP sent out again soon to go through this whole process of looking for a permanent vendor.
Is the vendor happy?
Yeah, everybody seems fine with it. We've only had one complaint. That was from a lady who failed the exam by 1 point, and she had an argument that something wasn't in the exam brochure. They started offering 5 test questions on that exam. Didn't count one way or the other. They didn't count toward their score, but they build in these test questions for future use maybe to see what the pass-fail rate will be, how tough they are, how easy they are, and they don't count the score. Well, she didn't know that when she went through the test. She said that would have had a bearing on whether she studied more or knew exactly how many questions she could miss. But
Well, bless her heart.
they
Take it over.
decided to.
Good grief.
Yeah. So, I mean, 3 employees she went through, and then to me with that argument. So she called the company, and they gave her a retest free of charge. So. But that's the only complaint
Do
we
you have
have.
any idea how many people are taking this with the vendor?
I know we had over 250 applicants pending. I would say half of them have taken it by now.
And what is the pass-fail rate? Is it
70.
consistent?
Still sir.
Still 70. I don't know. I haven't got. Do we get a report from them?
We have to log on to their website.
Yeah, we gotta log into. I'll get you a report at our next meeting and let you know how that's going.
I'd just like to know.
Yeah, that'd be good to know.
Because they just took pretty much the questions from the other examiner, is that correct?
They took
They've got
80 of the questions. Is all we could get out of the 300-item bank you had previously with the other vendor. They would only turn loose of 86 or 87 questions. So, yes, that's what they're tested on. 50 of those 80 are taken at random by each applicant.
Thank you.
All right.
Location manager application review.
Mr. Chairman,
Yes.
could I suggest we just take a very brief recess? real quickly, I promise.
Okay.
Be right back.
We'll bring the meeting back to order. Thank you, Susan. Location manager application review, determine eligibility. Tab number 9 is our first one.
Yes, sir.
Okay.
And you've got instructions there on the top of each page showing how they answered the questions regarding bankruptcies or other issues. And then the explanation on, like for this one on page 7, credit reports, highlights, she's numbered the pages.
I think that you got busted once before for denying somebody because they filed bankruptcy, because we can't do that. I think that how they're paying their bills right now is probably more important to us than the bankruptcy. I had an opportunity to look at this one while we were on break, so that's why I seem to know so much about it. Is there a way, or is there a report that the trustee or the attorney's, the applicant's lawyer can give us to show how he's doing on his bankruptcy, on his Chapter 13?
I would think the bankruptcy trustee could do that. but- Yeah, I was looking at this one too, and of course, if it's a Chapter 7, they're just all gone, and then you can see new
Right.
credit being issued. But when it's a 13, it's a little harder to tell from the credit report. So,
What about if you ask him to send, and he's been in bankruptcy for a long time, I don't remember, could be a couple of years. Is there something that he can show us that how he's doing in his, in the liquidation of the debts in 13? And Chris, is that?
I think that's reasonable, and I kind of think it's in line with the board's prior practice of, how are you doing recently? Just denying someone strictly for bankruptcy and that being the sole reason, legally problematic. But, if they filed, like you said, they filed bankruptcy 2 years ago and they entered into a Chapter 13 payment plan and they're paying as agreed, then to me, that's the equivalent of 2 years of a decent credit report, because, that is their credit, those are their obligations, so.
Does the credit report not tell you how he's doing since, or does it reflect the old stuff? What is it that he could give you separately? Did he file Chapter?
he filed 13, and it just says, it even said something about how we don't really know, since the payments are going into the court. I've read something.
Yeah, one of them said status unknown.
Status unknown. So, but the trustee should be able to, if he can hold it. There
Yeah.
should even be, I'm thinking I've seen in the past even a report of payments.
Or I guess it comes from the trustee.
It comes from the trustee, but you can actually see the payments and do it every month, so.
And it shouldn't be an issue, because this particular applicant has affirmatively made a representation in this letter here. I made all trustee payments as scheduled and anticipate the creditors will be paid earlier than stipulated. Okay, well, if that's the case, then whether you have that documentation or your attorney has it, or whether you have to ask for it from the trustee.
We just have to see the.
Yeah, I mean, it's, and the likelihood that this person would say that without the proof to back it up is probably pretty low. But at the same time, the board would feel better about moving forward with somebody's location manager application if they could have the paperwork to back it up.
If we had that paperwork, would we approve it? I think we would, right?
Yeah, if it shows.
So, can I make a motion that we approve this upon receipt of a trustee document validating his claim that he is up to date on his payments to the trustee?
Motion's been made
I second.
and seconded, all in favor?
All right.
Tab 10?
Yes, answered no to that question on bankruptcy or collections, but there are 5 negative accounts on the credit report, beginnings on page 24 to 28.
Oh, okay.
So moved.
Second.
Been made and denied, seconded, all in favor?
Aye.
Tab 11.
Tab 11 answered yes, that there were accounts and collections. You can see those listed on page 8 through 10.
$52.
I know, I don't,
Entertain a motion that we deny tab 11.
so moved.
Motion. Well, we can have discussion then. I don't want
Okay, no, it took me a while to get there. I'll second.
Okay, motion been made and seconded that we deny tab 11, all in favor?
Aye.
Tab 12.
Tab 12 was tabled by you on a previous review, and you asked for additional information regarding a closed and/or past due statement that appeared on his credit report. Her explanation is on page 2 through 4, and the credit report begins on page 5.
Child orthodontic.
Orthodontia, with braces.
Oh. Motion.
Move we deny.
Motion been made that we deny tab 12, all in favor? I'm sorry.
second.
And second is all in favor?
Aye.
Tab 13.
Never get praise. Tab 13.
That's down at the bottom.
Answered yes to accounts ever in collection. His explanation is on page 7 and 8. And receipts of proof of payments are on page 9 through 18. Credit report begins on page 19.
What page is this credit report?
19.
The ambulance bill paid.
Nope.
He's disputing it because he didn't file the insurance, but I'm sure it's timely filing. It's not going to be paid. But
Well, sometimes there are exceptions. I mean, and this one might qualify. I've done health insurance claim work before I came here.
yeah, if you
And
get
the
somebody
guys-
to look at it, yeah.
Yeah, if you get it to the right person, it gets somebody to look at it, and one of the exceptions is essentially urgent medical necessity. And if the guy's unconscious and couldn't give his information to the admissions folks, that's usually one of the exceptions they'll grant. But like you said, you gotta get somebody to look at it. And at the same time, he is on top of it and dealing with it appropriately. And so I'm not sure it's really fair to hold it against him for a car wreck where he was unconscious in an ambulance. And that's why insurance wasn't billed.
Well,
And everything else is subject to dispute.
I think all of it looks like
Yeah, I
he's
mean, it's
offered
a small
pretty good
amount of money.
explanation.
Everything else is paid except for the 2 disputed medical bills that didn't go to insurance.
Is there a motion to approve?
I'll make that motion.
Motion's been made that we approve
second.
13 and seconded, all in favor?
Aye.
Tab 14.
Tab 14 answered yes, that she had accounts and collections. The credit report begins on page 7 with the negative information showing on page 21, 43, 44, and 45.
They're taking a whole tree to make this thing in copies.
Then on page 4, she did put a post-it note explanation on her answer. Yes, it says unpaid items reported or due to disputes for services or lack thereof.
Where's the credit report again?
21, 43, and 45 is the negative information.
$95 utility bill.
Tell me what the term charge off means. I mean, that's kind of silly, but I don't know. Does that mean they discharged it from a bankruptcy?
No, in a accrual system, bookkeeping. You charge, when I charge the county my shop, I put it on as a receivable. When you don't pay me, I charge it off, take it off of my balance sheet. That becomes a charge off.
So like a credit card company?
Yeah.
That means she doesn't have to pay it?
No, she doesn't have to pay it.
Okay.
She
It
still
just means that it
can't.
doesn't show up on
It's just,
Visa's balance sheet.
yeah, the client doesn't show it up on their balance sheet as a receivable.
Okay.
I don't know about this.
If somebody wants to ask her why what looks like a vehicle loan was charged off.
So that was the one that bothered me.
That's the one bothered me
It's a Toyota lease. I think she needs to clarify what, she needs to provide explanation, especially to that one. But really, both of them, she makes a comment with a sticky note. How did she say it? That she was disputed because she disputed the service or didn't get it,
too.
lack
Unpaid
thereof.
items are reported are due to disputes for services or lack thereof.
And not that this is a reason to deny or grant anything, but somebody who's applying for a license with this kind of responsibility, it would seem that somebody would tell them something more professional than a sticky
sticky
note.
note.
You're due for an explanation of
Yeah. I move that we request her to explain these two items on her credit report.
I'll second.
Motion's been made and seconded that we request additional information on tab 14. All in favor?
Aye.
Tab 15.
Tab 15 answered yes to bankruptcy in '08 and accounts, whether there were accounts ever in collection. And the explanation for the accounts are on page 9 and page 11 of the credit report is the information.
Looks like this one is a chapter 7, not a chapter 13.
It does look like it's just that one.
Was this $98 bill to
that one.
No, it must have been since then. Everything else was current.
She is at 7.
Yeah.
Anything else current?
I make a motion to approve.
Motion's been made
Second.
and seconded that we approve tab 15, tab 16.
Tab 16 was previously denied by the board after a review of the credit report. He requests reconsideration on page 2. And on pages 3 and 4, he provides an explanation of the negative information on his credit report. And then their credit report begins on page 5.
This isn't posted though.
No, this is from actually a very well-placed law firm right down the street from the Capitol in D.C.
Wow.
They're asking a couple things here in that letter. They're asking for us to reconsider, of course, but also they're saying that if we're going to deny, they'd like to withdraw the application. Did you read that? Because it'll affect his status with he's licensed in other states. He'll have to report to them that he's been denied a license.
I did not notice that.
Maybe let me reread that, make sure I get it. Got it.
It looks like to me he's answered what our concerns were.
I think it would probably be okay.
Of course, if he'd have provided this the first time, he probably would have been approved the first time.
First time. I don't know how he couldn't have known about these things, but anyway, I make a motion that we approve.
I'll second
Motion
that
made
motion.
and seconded, we approve 16. All in favor?
Aye.
17.
17 answered no. There were no accounts in collections, but there's one negative item showing up on page 30 of his credit report.
It says no collections on file. Consumer requested it be closed. Payments managed by financial counseling program. Nothing else negative on there.
We
Make a
approve.
motion to approve.
Motion
Second.
made and seconded that we approve tab 17, tab 18.
18 is a reinstatement request, and I would like you to waive retesting License expired 12/31/10. He paid a renewal fee at that time, but the form was incomplete. See his explanation on page 2. He was licensed from 02 to 2010, 12/31/2010.
He's been in the business continuously,
For 8 years, yeah.
And it looks like he paid what he was supposed to pay on time, so it's like he missed a signature on one form.
And the board mailed the form back to him, certified mail, and he showed receipt on page 5, where, for whatever reason, it was unclaimed that it never got returned to the board either. So the transaction just expired in the system, so we didn't catch it on the review.
I move we grant his waiver request.
Motion made and seconded that we grant his waiver request. All in favor?
Aye.
Item 19.
Tab 19, this applicant disclosed a misdemeanor charge. You'll see it on page 5 that was dismissed. But there's negative information showing on his credit report on pages 9 through 11.
Domestic violence, battery charge, is that
Yes,
That
but
depends on, it varies,
somebody got hurt?
or if a weapon was used.
Hey, did you say page 11?
page 9 through 11 is the negative information.
I move we deny based on
On the credit.
credit.
A second.
Motion's made and seconded that we deny tab 19. All in favor?
Aye.
Well, that concludes all of the location manager applications. But we do have 2 decisions we'd like to ask you on about based on company applications. Tab 20 is a request for you to reconsider the denial of their application at the last board meeting, and that denial was based on 6220-106-2 and 4 because they could not or did not submit a 6-month operating budget and financial statement. Their request for reconsideration is on page 2, and an explanation from their CPA is on page 3. Their financial statement and 6-month budget report is on pages 4, 5, and 6. Same operating budget that we saw before? Yeah, that was received December the 10th, so it was denied.
Not showing any.
And what's so hard about,
I know, that part, I don't get that.
If they do a proper,
I know.
it's not that hard.
Are we okay with this financial statement?
Yeah, I guess. I mean, I mean, of course, part of this 6 months is revenue. What does he expect to get from this client? I mean, he's bound to have some projected revenue. How does he even know he wants his business if he doesn't have any projected revenue? Which I don't see anywhere. I mean, yeah, he's got some expenses, but
I think, can we send him a letter and say, we feel like it's your financial statement, you answered the questions on your financial statement, but a proper 6-month projected statement.
budget.
Income and expenses.
Including projected income and expenses.
Yeah.
And then the other question I had, they also submitted at the same time a location manager application. Has that been approved? Yes, Susan, it has?
Yeah, it was approved at the last meeting.
Okay, so they do have a
Agency
location
was
manager.
here.
Okay, good.
and has he taken the test? Passed the test?
Oh, so he hadn't,
He was approved
He's
to
approved
take
to
the
take
test.
it.
oh, okay. But obviously, that's the second issue. You can't open without the location manager.
But you said including the projected what?
We need
Income.
to projecting,
Income and expenses from,
even if they say, you know, we can't project any income for the first 6 months, that is a projection. You know, do at least tell us something that you're planning on operating in the hole and out of this 200 whatever thousand surplus you have.
Right.
If you're,
that's right.
That's fine. We-
perfectly acceptable. A lot of businesses run that way
Right.
at first. But
A lot of them run that way.
Well, if they do provide that, is that all the board wants, that we go, if it's satisfactory to Mr. Whitaker, we approve it?
I think so.
Yeah, they,
So just the 6-month operating budget with those
Yeah, no
projections?
hard to be, but in any event, yes, I think
yeah, it's,
I move,
it's okay.
I move that we approve this application upon receipt and approval by Mr. Whitaker of a proper 6-month pro forma statement, including projected income and expenses, and that all other requirements are met, including the location manager
Passing the exam.
passing the exam.
I second.
motion been made and seconded. Is there any discussion? All in favor, say aye.
Aye.
Tab 21.
Tab 21 is another business application. It's a new application that we'd like you to review regarding a settlement agreement in North Carolina on pages 5 and 9. You'll see that information, and we have discussed this with Mr. Whitaker. He recommended approval, but just wanted to let you review it. And
I
page
looked at it, I
5,
think it looks,
at the bottom on the application, they disclosed in 2010 a voluntary settlement agreement with the state of North Carolina regarding a lapsed collection license, and a copy of the settlement agreement was enclosed.
And the reason I brought this to you, because if it were a situation, there are some of these settlement agreements where they're no-fault settlement agreements, where the agency in question doesn't even acknowledge or admit that there was any violation that occurred. They're just paying money to settle a disputed claim. And on those, I don't really even recommend that those be brought to you, because there would be nothing upon which the board could base any potential complaint or disciplinary action, because there's no omission. But in this case, one of the provisions says, whereas respondent has acknowledged and admitted. So there was an acknowledgement and admission, although of something relatively minor in the grand scheme of things.
It's just a license lapse, right?
Right.
And they have licenses in multiple states,
They do.
evidenced by the states they do business in. I move we approve this, Mr. Chairman.
Motion's been made and seconded to approve tab 21. All in favor?
Aye.
Ta-da! Is there any other business, new or unfinished? We adjourn. One thing I can.
Yeah.
We're going into the new legislative session. If we get any bills that change any laws or presented to change laws, I will bring them to you at the board meetings that come up. We'll email them. We'll let you know. I'll let you know.
Elizabeth just let me know that May 15th, she will be available for our meeting that day. So, but she has to go to Europe.
Bless her.
Darn.
She wants to
Can we have the meeting there?
We'll meet you there. So, I think I'm okay with it, but Chip might want to check.
Yeah, so far it looks fine for me.
I just wanted to let you know ahead of time, because I know that is getting into vacation time, so.
I might be going to Bordeaux that day or something really.
Need to
Yeah,
reschedule. I would,
Not here.
not any time in May is good for me, but if that helps somebody
Okay.
else.
But you're going to Omaha.
I've got pretty much whole month,
Okay.
yeah.
You'll be gone from that baby tomorrow.
I figure now's better than he won't remember that I'm gone. I'll be back for his birthday for sure.